we have been doing for the past 1 week is to talk about the fundamentals of private international law. Now, I will take 2-3 minutes to revise what I have done in the last week, and then we'll move ahead. So, last week we talked about certain fundamental points. The first point which we talked about last week was that foreign element is, say, a distinguishing criteria of private international law. So if you remember our discussion in one of the first lectures, we took 2 examples to show as to how one case involved foreign element and the other did not. Secondly, we also talked about different stages, and very briefly I highlighted what are the different stages of a private international law dispute. So different stages of private international law dispute. The first thing which we studied was jurisdiction. That in every private international law dispute, that would be like the first question to be ascertained. Okay. Hi, good morning. Yeah. Now, then, of course, the second thing which we studied was the applicable law. We thought that once the question of jurisdiction has been satisfied by the court, the next thing for the court to decide is that which law would apply to the dispute at hand. The third thing which is involved in a private international law dispute is the recognition and enforcement of foreign judgment and awards. Now, let me speak at least 1 minute each on all these 3 issues. Now, just forget about a private international law dispute having a foreign element. Think about a purely domestic dispute itself. In a purely domestic dispute, the moment a matter reaches the court, the first thing which the court does is to identify the jurisdiction, whether it has jurisdiction to try the case or not. So if I am accused of murder and my case is pending before a court, the court will first look into the fact whether we have jurisdiction to try this person or whether some other court with some other competence can look into it. The second thing would be to look into the applicable law. Fine, this person is accused of XYZ things. Now, which law is going to apply to this person in terms of deciding that matter? So these are the 2 things which is present in almost every case, including a purely domestic matter. But in private international matter, this gets a bit technical. This gets a bit technical because the question of jurisdiction often appears in conjunction with other courts also exercising jurisdiction. So there might be a scenario where on the same subject matter between the same parties, 2 or 3 courts can exercise jurisdiction. And that's why it becomes very important to ascertain that whether a particular court has jurisdiction in relation to a particular matter involving foreign element or not. Similarly, when it comes to applicable law, generally in a purely domestic matter, what applies is the municipal law of the country. But in matters in disputes involving foreign element before a court, there could be a scenario where, say, a foreign law might also apply. Therefore, identification of applicable law itself is a very significant issue. Thirdly, in recognition and enforcement of foreign judgments would mean that a foreign court has already pronounced the judgment, but it has to be implemented in some other country and not the country where that court is placed which has pronounced the judgment. Now, how does that process really works? Of first recognizing the foreign court's judgment and then enforcing the foreign court's judgment. So this was the second aspect which we studied in the past lectures. The third aspect which we studied in the past week's lecture was about the definition of private international, and we have spent time in terms of talking about all the 4 elements of the definition of private international law. Further, we went into this exercise of identifying the reasons for private international as to what justifies this field called private international law. In this regard, we made the point that private international law is primarily municipal law. In terms of talking about the reasons, we referred to Cheshire's identification of reasons, which included that if we invariably or mechanically apply foreign law, then that would lead to gross injustice. And the example which we took was that of marriage. That imagine a couple getting married in Germany and coming to India, and in India they are having some matrimonial dispute, and Indian court applies Indian law and says that your marriage is invalid, but by German law their marriage is valid. So that would lead to gross injustice if a situation like that happens, where they are married in one legal system and unmarried in another legal system. We also saw that if we apply the law of the forum mechanically or invariably, then it will also modify the legal obligation of the parties concerned. We took the example of the contract. So this was the third point. This was the fourth point which we studied in the past week's lecture. The fifth point which we studied in the past week's lecture was that how Comity of Nations is also identified as a reason for private international law. However, there are scholars who are critical of Comity of Nations being identified as a reason for private international. They are unhappy mainly because Comity of Nations is an indeterminate term, maybe a meaningless term, which is often invoked in a misleading way. Also, it is incompatible with an idea that judiciary is not supposed to look into foreign relations. Rather, it is the work of the government. So it is a policy question rather than a judicial question. We also discussed how just because rules of other countries are invoked, that does not mean that the sovereignty is at stake. Because in applying the rules of other countries, these nations or these courts are not considering the foreign body of law as a superior law. So sovereignty is very much intact. Now, in terms of talking about the fifth point emerging out of it, what we discussed was the issue of space and time. So we said that how private international law, and with the help of examples, I tried to explain as to how private international law does not follow or does not subscribe to the traditional notions of or conventional notions of space and time. That was another point which we studied during our discussion. Further, we talked about the unification efforts of private international. So we saw as to how there are different efforts in terms of unifying the rules of private international. Now, we said that unification can happen in different ways. Maybe first would be to say unify internal laws, but that seems to be practically difficult, if not impossible. Then, of course, the major attempt which is made is in terms of unifying the rules of private international. We saw as in how in Europe, the trend or the tendency of unification is much more higher than in other parts of the world. Lastly, what we covered as part of our discussion in the preceding lecture was the issue of name of the subject. In so doing, we also focused on the difference between private international law and public international law. We saw as to what are the major criticisms with regard to the title of the case called private international law. Subsequently, we also tried to cover the idea of conflict of laws and say that an alternative which is proposed, an alternative to private international law which is often proposed is the title conflict of laws, which seems to be equally problematic for precise reason that it is also misleading and it does not really confirm with the nature of the subject. Be that as it may, what we concluded in the last lecture was that no title is accurate, nor is any title comprehensive. I mean, the two titles are though not accurate and comprehensive, but they are so well known that the moment you refer to these two titles, it's almost clear that you are referring to a particular body of law dealing with the application or the possibility of application of foreign. So these are the 8 or 9 points which we tried to cover in the last lecture. Now we move ahead. Now we are moving towards more concrete areas of private international law. We started with broader questions of scope, nature, definition of private international law. Now we are continuing with the discussion, but maybe fine-tuning it. We are bringing it to more specific questions. Now, in this week, what I intend to cover are the 3 stages of private international law dispute. So, if you remember, and something which I said minutes back, that every private international law dispute involves the question of one, jurisdiction, two, the law which applies to the given dispute, based on which the judgment would be rendered, and third is the question of recognition and enforcement of foreign judgments. Now, this week I'm going to talk about all these three elements, particularly the first two, because the last one there is a separate module in your syllabus. So maybe we'll be spending enough time on it with the help of case law. So my primary agenda would be to talk about in detail at least the first two elements, first two stages. In so doing, we will also talk about a number of important concepts in private international law. So we will talk about doctrine of renvoi, anti-suit injunction, forum non-convenience. So all these aspects we are going to cover during this lecture. All right. So today we begin our discussion on jurisdiction, but in a much more detailed way. Now, if you look at the question of jurisdiction, it's very strange, because when I was preparing for today's lecture, I thought that I should at least look at different writings which are there on this issue. So I picked up Cheshire, and when I picked up Cheshire and looked into the section on jurisdiction, I found that the brief description of jurisdiction which has been given is mostly a reflection of English practice or British practice, which of course would reflect common law on the point, but that is how Cheshire has tried to introduce this topic. So I thought that let's make it more precise for the class to see that maybe, to give a more contextualized introduction in terms of how Indian courts look into the scenario. So I picked up Govind Raj. Yesterday I've sent a material on the Google Classroom. You can have a look. Now when I picked up Govind Raj's book, Govind Raj uses another methodology. Govind Raj uses more of a rational methodology in terms of referring to US restatement of conflict of laws, and says that there are some general trends emerging out of the question of jurisdiction, and these are some of the general trends. Again, the discussion specifically on Indian position was missing, but he tried to introduce the question of jurisdiction in a much more general sense. I picked up Lakshmi Jambolkar. Now, what she has done is to pick up case laws, and through case laws, she has tried to explain how jurisdiction actually works in relation to disputes involving private international law in India. Now, what is important about all these three writings? What is the distinguishing feature of all these three writings? For me, it looked like all these three writers were using different approaches to study the question of jurisdiction. So Cheshire relying on British practice, Govind Raj fundamentally taking a more of a rationalist position and saying that, okay, this looks a better position in terms of how jurisdiction is placed. Lakshmi Jambolkar, more of a case analysis method. Now, why is that the case? Why are they doing it? Why can't they look at such an important question of private international law in the same manner? Now, that is a question which should trouble us. That if private international law begins with, if the stages of private international law, they start with how jurisdiction is placed, then why can't they have one uniform way of handling the question? Why have different approaches to look into the same question? There's a particular reason for this. And the reason is that there is not one single document, there is not one single instrument which deals with the question of jurisdiction. So there is not called one jurisdiction act or legislation on jurisdiction which will give answers to all the questions, scenarios, permutations and combinations of jurisdiction. One has to refer to different laws, different legal systems, and within one legal system, many laws, to study the idea of jurisdiction. For instance, in India, the legislation which deals with the question of jurisdiction most comprehensively is a piece of legislation called Code of Civil Procedure, or Civil Procedure Code as it is known as, CPC. But even it does not capture all the nuances of jurisdiction. So for subject-specific areas, you might well look at some of other legislations dealing with those areas. So for example, with regard to custody of children, we might have to go to a law called Guardians and Wards Act. Similarly, with regard to, say, question of matrimonial disputes, we might have to go to another different matrimonial legislations to find an answer to those questions. So the point which I'm trying to make here is that the question of jurisdiction is not decided by one single legislation. That, okay, this is the final point, and then beyond this point, there's no discussion possible. No, question of jurisdiction is a much more fragmented question. There cannot be one answer to it by reference to one single legislation. And it is for this reason that different scholars end up using different approach. Will also invoke their ideas wherever it is needed. So that is what we intend to do today. Now, the next question which comes up for discussion is that what is jurisdiction? How can we define jurisdiction? Now, there could be a very simple definition to it. A very simple definition to jurisdiction could be, say, it implies a scenario, or it implies a situation where a court will entertain a suit. So it basically is a triggering point. A triggering point which signifies the situation or the point or the justification rather for a court to entertain a suit. So the moment we say that this court has jurisdiction to look into a matter, what we mean is that this court is competent enough to decide the matter. Now, that is what fundamentally we mean by jurisdiction, if you really ask me to define it in simple terms. Now, jurisdiction is always defined by the lex fori. What do I mean by lex fori here? What I mean by lex fori is that the law of the forum. What is the forum in this law of the forum? The forum is the court in relation to which we are exercising or we are discussing the question of jurisdiction. So, if the issue is that of a jurisdiction of an Indian court over a matter involving foreign element, then the distinguishing part is that the Indian law would help us decide whether that court has jurisdiction or not. That is the point which I wanted to make. Now, jurisdiction has also to do with larger principles of public international law. I'm sure last semester you studied public international law. You will be able to recall that there was a specific section in public international law dealing with jurisdiction. And we saw that how the idea of jurisdiction is significantly linked to state sovereign equality, maybe non-interference, and also and there are also exceptions to it. Can anyone identify or can anyone explain as to what are the connections between the question of jurisdiction in this regard? How the question of jurisdiction can be linked to public international law and how public international law tries to look at the question of jurisdiction. Anyone able to recall something from the last semester? the last semester we had a discussion on, say, how jurisdiction is fundamentally linked to sovereign equality of states, in the sense that, or idea of sovereignty, that all states are sovereign in their relationship and therefore autonomous, and therefore each state or the other state is not supposed to interfere in the internal relations or the external relations of that particular country. Now this determines that each state is sovereign in terms of its own territory, and there is certain. Yes, please. Yes, someone is trying to speak. No. Okay. Now, so the question of jurisdiction also brings into picture the issue of autonomy of states. That each court has its own autonomy in terms of dealing with a fundamental issue. So, for example, a foreign court must have some justification if it is trying to look at a dispute which has taken place in India. There must be some connection, there must be some justification, some close connection between the forum which is supposed to decide the dispute and the dispute itself. At the same time, one also needs to see that this becomes even more important, because as a matter of policy, states are sovereign and therefore autonomous of each other, and therefore just because a judgment has been pronounced by one court over a dispute which is to be enforced in another country, then it cannot be enforced without the help of that particular country. Therefore, enforcement jurisdiction is fundamentally related by the principle of territoriality. Now, that's an important facet which we all must remember. Now, what are the exceptions of? And therefore, to close that point which I'm referring to, is that question of jurisdiction also reinforces the idea of sovereign equality and principle of non-interference. But then something else comes to the picture, and that is, since I'm just mentioning about it, and just to test, and not to test your memories, but just to know as to how well you understand this area. So when you're studying public international law, we talked about exceptions to jurisdiction. Anyone can remember what exception were we talking about? Any idea? Anyone can recall?
So maybe regarding the councils, the diplomatic missions in other states, the particular states in which the missions were physically situated did not have that kind of jurisdiction, which they normally did over the other parts of the country.
Yes, that's a good response in terms of how there could be certain exceptions to jurisdiction. Right? So we will talk about, maybe today itself or tomorrow, as to how one of the provisions in Civil Procedure Code talks about that even when a state has jurisdiction, in certain situations that state would be prohibited, that the courts of that state would be prohibited in terms of invoking that jurisdiction. Immunity, diplomatic immunity being a very good example. The question, I would try to put the question differently now. Thank you so much for that response. That's a wonderful response. That can there be a scenario where there is no link between the forum state and the act which has been committed, but still the courts of that particular state, or the court of the forum state can look into that matter? Can there be a situation like this? So I have tried to put the question upside down. Have you heard of a concept of jurisdiction which captures what I just said?
Sir, maybe the cases where I don't recall the exact term, but in some cases the dispute involved is of such a nature that any any jurisdiction, any country can invoke the jurisdiction. For example, like cases, the crimes against humanity.
Wonderful. Now, this is known as principle of universal jurisdiction. Now, this is a very good example, in fact, that there are certain situations which are of such a nature that every court may exercise jurisdiction over. Universal jurisdiction is a universal jurisdiction in relation to crime against humanity, war crimes, genocide. These are good examples of universal jurisdiction. So even if crime against war crimes, for example, or genocide was not committed on a particular territory or against the individuals of that country or by the individuals of that country, a court may exercise jurisdiction by applying this principle of universal jurisdiction in terms of how it is recognized by international. So this is a point which I just wanted to mention in passing, because as students of international law in general, you must know about these issues. Now, the general position with regard to how the issue of jurisdiction is placed is that it is mainly territorial. Jurisdiction is fundamentally territorial, but at the same time, there are some students who are trying to join, and it becomes very, I would say this becomes very disturbing for me to see these chats, because the request comes regularly. Can you tell your friends if there is a WhatsApp group that they can join with the DU ID, because for that they don't need permission. They can directly enter into the class. So you can just drop a text whenever it is free. I'm unable to read the chat because of these regular requests, which is always there on the screen, and then I can't keep on adding each one of them separately. So just request them that if they can use their Delhi University ID to join these classrooms. So the point is that although the jurisdiction is mainly or primarily territorial, it can also be on the grounds of, say, citizenship, domicile, or habitual residence. So over a period of time, the grounds on which jurisdiction is invoked or established has increased. In fact, in some cases, court has gone to the extent of saying that the closeness of the party with a particular legal system could be a ground of justifying the jurisdiction of the court. Now, that itself is a loose but an effective way of invoking jurisdiction, if at all you follow what I'm trying to say. Now, when it comes to the issue of jurisdiction, one question which I'm sure which would trouble all of you is, how is this question of jurisdiction different from, say, other disputes which are of purely local character? There was a question in the chat which I'm unable to see on my screen because of these requests. If it's all right, can you speak? Or else maybe once these requests stop, I will open the chat and then we'll read it. Or else you can speak. I'm unable to see it, and therefore I'm very sorry.
That's not a question, sir. I was just contributing to the discussion on jurisdiction, and I was mentioning the erga omnes obligation from which no derogation is possible. So that is also part of universal jurisdiction.
Yeah, wonderful. Yeah. So what Donica is, yes. Yeah, so what Donica is referring to is that universal jurisdiction is generally invoked in relation to those obligations which are considered as erga omnes. Now, erga omnes obligation implies that, now the request is gone, so I can see that. Yeah, so erga omnes obligation implies that there is an obligation on part of all the states. So unlike what Donica writes here, from which no derogation is possible, is more in terms of just cogence norm. Erga omnes is one of the attribute of just cogence. So erga omnes basically talks about a scenario where an obligation is on part of every state, but this erga omnes obligation is one of the central elements in defining the principle of just cogence, or what is also known as peremptory norm of international law. And in terms of defining peremptory norm of international law, the element which comes into picture is that it is a norm from which no derogation is possible. Thank you so much again, Donika, for putting it that way. Now, as I said, moving forward with our discussion, when it comes to the issue of jurisdiction, the question is that how does jurisdiction really works in a purely domestic matter? And why are we looking into this issue? We are looking into this issue so that we can really understand that what is it that is required in a case having foreign element that differs from say a purely local matter, right? Now it is in this regard that let me identify the different minute elements of the issue of jurisdiction in local matters. The first thing is the issue of notice, which is identified in relation to jurisdiction in a purely local matter. After notice, there is something called opportunity of being heard. Now, third would be following up of procedure as has been established by the necessary legislation. And the fourth would be a culmination of all these procedures leading to a fair trial. So these are some of the fundamental processes involved in a local matter. Maybe initiation with notice, then opportunity of being heard, both reflective of principle of natural justice, and then orderly procedure and a fair trial. Now these are some of the fundamental elements. Now look at a dispute involving foreign element. Imagine merely giving notice without any opportunity to appear before the court or without being heard. Now that will make the entire judgment as useless or an empty threat, maybe an empty pronouncement. Let me explain this point. Imagine there is a dispute between two persons, a contractual dispute between two persons. One of them resides in, say, England, and the other person resides in India. There's a dispute. The matter reaches Indian court. Now, Indian court decide that yes, we have jurisdiction, and a notice is sent, and the proceedings are initiated. Through that notice, they invite the other person to come and participate in the trial. The other person says that we don't recognize the jurisdiction of India, and therefore he or she does not render her or his defenses. Now, the court comes out with a verdict. Now, when the court comes out with a verdict, then what happens? I mean, the verdict applies only in India, but the person lives in England. How does that make sense? Now, the matter has to go it has to be enforced in the foreign jurisdiction. And in order for that to happen, what is important is that there should be clarity on all these issues which I just identified. Notice, opportunity of being heard, orderly procedure leading to a fair trial. Only then a foreign court would say that, yes, I agree with you, and therefore your judgment needs to be enforced. And therefore, the starting point in this entire scheme of things is the issue of jurisdiction. If a foreign court has an iota of doubt that the court whose judgment they have been asked to recognize and enforce did not have jurisdiction, they will reject the entire verdict then and there. And that's also one of the exceptions specifically identified in Civil Procedure Code for not recognizing the judgment of a foreign court. In addition, there have been a number of other concepts which have grown around this idea of jurisdiction, especially in relation to disputes involving foreign element. One of these concepts, for instance, is the concept of forum convenience. I don't know if you have come across this concept of foreign convenience. It would broadly mean that when deciding a matter whether to allow any other court to exercise jurisdiction over a given matter, the court will consider the fact whether a foreign court is the most appropriate forum or the present court is the most appropriate forum to decide the matter. And this is known as principle of forum convenience or forum non-convenience, in the sense that court decides that the present court is not the best suited forum or present court is not the most appropriate forum to decide the matter at hand, and some other court is the appropriate forum to decide the matter at hand. Now, so these concepts which have grown around the principle of jurisdiction further complicates the issue of jurisdiction. And therefore, even if a court accepts jurisdiction, the judgment of that particular court has to be enforced. And if it has to be enforced in some other country, it becomes very important if the issue of jurisdiction of what we are talking about. We are talking about the first step of a dispute involving foreign element, which necessitates the application of foreign law, for instance. Any questions till now?
Sir, can you just once summarize what all we have decided regarding the question of jurisdiction, like point-wise?
Okay.
Like the bullets that we have. Thank you.
Fine. So, as I said, the first stage of a private international dispute is fundamentally jurisdiction. Now, when we started talking about jurisdiction, what I referred to was that there are different approaches to dealing with this issue of jurisdiction. So, we have Cheshire, for example, who looks into practice and then decides the issue of jurisdiction. Govindra, for example, looks into more of a rationalist justification of how should the question of jurisdiction should actually work and how it has been working in US, for example. Lakshmi Jambolkar looks at the case laws. There could be other ways of dealing with it, in the sense that we can go to specific statutes and then decide the question of jurisdiction. Now, so the first point which I made in the class discussion is that there is no single instrument to decide the question of jurisdiction. There's no one document which will help us answer the question of jurisdiction. There are different documents, there are different practices which will help us decide as to whether a court have jurisdiction or not. Second point which we made was that jurisdiction necessarily implies or signifies as to when a court will entertain a suit. So, by virtue of jurisdiction, what we decide is that whether court is competent enough to decide that particular matter or that particular dispute or not. The third point which I made was that municipal law of the lex fori, that is the law of that is the forum or the court which is dealing with the matter, would decide the question of jurisdiction. So the question of jurisdiction is not externally imposed on the institutions, rather it is internally supplied. So municipal courts basically pronounce the issue of jurisdiction. I briefly mentioned about the public international law notion of jurisdiction and how the question of jurisdiction is an important issue when it comes to public international law, and to a large extent the institutional character is defined by how public international law defines the idea of jurisdiction. Fundamentally, taking it back to the concept of sovereign equality, principle of non-interference. There could be certain exceptions to it. Principle of universal jurisdiction is a good example. So that was the fifth point which I wanted to make, that each state is autonomous in terms of dealing with disputes, and since each state is autonomous by virtue of sovereignty, therefore the other states are supposed to respect this judicial sovereignty of other states and not supposed to interfere with it. So that was one of the points, universal jurisdiction being an exception. The sixth point which I wanted to make was to highlight a general trend, of course, which I'm going to talk about in detail. And that is that in order for jurisdiction to be established, there should be some link. There should be some link between the forum and the dispute at hand. So, for example, territoriality is one of the most accepted notions in this regard. However, there could be other grounds as well. Other grounds could be citizenship, say domicile, say habitual residence. So all these elements could be present in terms of how the jurisdiction is decided. Having said that, the next point which I made was that although jurisdiction can be decided by a court in terms of how or whether to deal with this matter or not, but enforcement generally takes a more difficult turn. Therefore, if a judgment has been pronounced by a court and it has to be implemented in a foreign legal system, then the officers of this court or the enforcement agency of this court cannot just walk into the territory of another country and enforce that judgment. Rather, a request has to be made to that other country that a following judgment has been passed and it has to be enforced. And therefore, question of jurisdiction also becomes important jurisdiction also becomes important in order for effective implementation of a verdict or pronouncement. That's the seventh point which we made. Further, what we talked about was the difference between the nature of a trial which is purely local and something which is transnational, or the one which has foreign element involved. And in terms of locating this difference, which we did minutes back, we saw that how there are different stages. Notice is there, opportunities of being heard is there, then an orderly procedure has to be there, ultimately culminating into a fair trial. In disputes having a foreign element, mere notice will not do. It means that the question of link, which we often don't ponder over, the question of link which we often don't consider while describing or analyzing a dispute of local nature, emerges as a very significant factor in a dispute having foreign element. If we don't do it, then the judgment pronounced by the court would merely be an empty threat. Similarly, and the continuation of this point is that there are other concepts which have grown around the idea of jurisdiction. And the example which I took was that of forum convenience, where a court will say that which is the most appropriate. The court does have to look into an issue that which is the most appropriate forum to decide the matter. And in order to do it, court will look into the close connection between the matter at hand and the forum itself. Yeah, so these are 6 or 7 points which I wanted to make at the beginning of this discussion in jurisdiction. Are there any questions? I think I've summarized it to a large extent. What I did over the past 30 to 40 minutes. Any questions here? Okay, there are no questions. Well, yesterday there was a request which I found to be very genuine, and the request was that if we can cover less in our class discussion, that appeared as a very, very genuine request, where it was said that maybe we are covering a bit too much because of the online lectures, because we are not bound by a certain kind of engagement which we used to have in classroom thing. So, I mean, because students also need to go and study and then process what they have studied. And I feel extremely sorry if you feel something like that, and I have been completely oblivious of such limitations, that maybe we are trying to cover too much in these lectures. So I'm perfectly fine. Maybe we will try not to have tutorial classes for a few weeks to see that how it goes, and once we are into the meat of discussion, and then of course we can invoke tutorial classes, unless of course you have some questions, then we meet and have a larger discussion. I mean, do you also feel that? Because I found that request to be very genuine, and at least 2 such requests, both from the papers which I am teaching this semester. I mean, is that fine for today, or do you want me to go ahead? Because I can. We can continue the discussion. Anyone? Any observation? Any comments? Yes, no? Nothing? Do you agree, disagree? कुछ तो होगा. No, you don't. Okay. No, I'm perfectly fine, and at least I found the request to be very genuine, and often we sitting on the one side don't realize certain limitations. Okay, fine. Let me at least go one step ahead, and then we can stop. At least for a few weeks, then we might consider not having tutorial classes, and then we can. I'm more than happy to take tutorial classes and continue our discussion. We can also discuss any other issue which you want me to discuss. But I'm completely fine with that idea of. I'm completely fine with that idea of maybe relieving us a bit in terms of what we are covering. Fine, we go one step ahead, and we say that what are the connections we are talking about? What are the kind of connections that we are trying to develop here, or we are trying to invoke? Now, there could be quite a few bases of judicial jurisdiction. Now, Govindra, for example, if you have read that article, you find that he mentions quite a few criteria which might be instrumental in, say, establishing jurisdiction of a court. So, for example, he talks about presence. So if someone is present in a given jurisdiction, in a given territorial jurisdiction, for example, which of course empowers the court to exercise the jurisdiction, then that is a good point. Similarly, he also refers to the criteria of domicile. Especially in matrimonial matters, criteria of domicile is quite significant, where domicile helps define the issue of jurisdiction. Subsequently, residence could be a very important criteria. And when we are saying residence, there is a concept called habitual residence, something which we will study in the next module. Again, the residence part helps us create the link between the forum, that is the court, and whether that court is the apt forum to exercise jurisdiction or not. In this regard, I would refer to Guardians and Wards Act, Section 9. And Section 9 of Guardians and Wards Act specifically refers to habitual residence, in relation to which or where a suit can be filed in relation to custody of a child. Similarly, nationality or citizenship could be a ground of determining jurisdiction. Consent could be a ground of determining jurisdiction, that although the person is not present, although the person is not domiciled, although person has no residence in a particular country or is not a citizen of that country, still the person has consented to participate in the entire trial. Again, you can easily see the link. Similarly, appearance in an action, meaning thereby that there was a case filed and the person appeared before the court to oppose the jurisdiction. Now, in many municipal legal systems, such a ground is not considered as an apt ground for exercising jurisdiction. But in India, there are few cases where courts have exercised jurisdiction by appearance in an action. Similarly, if you are doing business in the state, so even if you are not physically present there but involved in some sort of commercial exercise or business in a particular state, then that could also be a ground for exercising jurisdiction. Similarly, an act which is done in a particular state. So even if you are not present there, not domiciled there, not have habitual residence, no nationality or citizenship, the consent was not there, appearance in action was not there, but there was some act which was done in that state, that could also be a good enough ground for court to exercise jurisdiction. Similarly, if that act was not done in that state but done somewhere else, but which had an effect in that particular state. So there are three countries, A, B, and C. And person X is a citizen of state A, and he does certain act in state B, which had some effect in state C, but he did not do any specific act in state C. Even that can be considered as a ground of exercising jurisdiction. Similarly, ownership or possession of certain property in a particular state, and other relationship to the state which makes the exercise of judicial jurisdiction reasonable. Now, what is the common aspect emerging out of this entire list which I just read? The common thread in these entire points is that there is some link, some connection, some sort of relationship between the forum state and the party. And therefore, what is important is that the question of jurisdiction cannot be isolated from the fact that a connection has to be established. A particular kind of connection has to be established if at all we are to argue that the court in that the court has jurisdiction in relation to a particular dispute. That's the last point which I would make today. If at any point of time, yeah, it can eventually, because these are two different legal. Yeah, Donika, that's a very good question. These are two different legal categories, but it can turn into domicile if one is able to satisfy all the criteria of domicile. Similarly, that the person wanted to live there permanently, or the intention was there to live permanently, then of course it can easily turn into, say, domicile. But a person is living in a country but doesn't want to live there permanently, and he believes that whenever things are better, whenever he is done with his business, he will go to a particular place where he is domicile. Then of course we will make a distinction between habitual residence, where a person is there just to do business or some other work, but does not intend to reside there permanently, which of course is one of the defining elements of domicile. I hope that answers the question, Donika, that yes, if all the conditions are satisfied, of domicile are satisfied, then of course habitual residence can also get transposed into domicile over a course of time, but not necessarily. Not all the time. We'll have to look into different considerations. Yeah, so that should be it for today. We meet tomorrow if at any point of time